by ships. We will have several introductory intervention, a welcome speech by our chair of the group GUNGL, Mrs. Gabi Zimmer. Then we exactly begin the really technical and political introduction, as in the program, beginning from Sabine Wills, who is our shadow rapporteur in the legislative procedure regarding the port service opening the market on the proposal of the Commission that you absolutely very well know, on which the debate is open, and on which the first vote in the TRAN committee will be probably postponed to the session of March of the TRAN committee and not on the 12th, not on the 11th of February, but it is not yet confirmed. So we are working with the other groups, with you mainly, for the next vote in the TRAN committee, and it's probably for the vote then within the April last session of this Parliament. So welcome to everybody. We'll have approximately 8 minutes of each introduction. Then the proposal that each of you please show to me, to Gerald, to the boys and girls who are here on my right, in order to have your names, and have 5 minutes each. We can, everybody took the floor and make comments on this proposal and on your proposal mainly.
Ich möchte das Podium. I want to introduce the panel, please.
Ah, yes. I leave
I
the...
will do, yes. Ja, guten Tag.
Yes, good afternoon. Welcome to our hearing this afternoon. As Umberto has already said, I'm the shadow rapporteur for the GUE NGL on this port services dossier. Now, if I may just introduce you to the speakers here at the podium. On my left, Dimitris Torokis from the European Commission. I can't really pronounce his name very well, but if that was okay, mobility, transport, and so he's the department head in the field of inland waterways and ports. Mr. Dietrich from Germany, he's the working director of the Hamburg Ports Company. On the far left, Livia Spera from Italy. She is a union secretary for fisheries and ports, part of the European Transport Federation, the ETF. Then on the right-hand side, Georgios Govos from Greece, union secretary in the field of port services in Piraeus, Athens. Then Anthony Tedao from France. He's a coordinator for the Port Workers Union, the International Dockers Council, the IDC. Then Mauricio Colombai from Italy. He is coordinator for the National Port Piloting Services in the Italian CGL Union, Confederation of Unions. So thank you very much, everybody, for being here and for being willing to speak at the podium. Roberto, you can go ahead now.
Gabi.
So Gabi Zimmer is the chair of our group here. Up to you. Choose.
Thank you very much. Ja, ein herzlich.
Yes, welcome to everybody who accepted our invitation, the invitation sent out by the GUE NGL, a group here at the European Parliament. We have quite an exceptionally qualified speaking panel here this afternoon, so it should be an excellent debate that we have on the new attempts to liberalise port services, and we'll go into some detail in the debate. Hopefully we'll manage to get to the bottom of the quality differences between the attempted liberalisation through the services packages that we've had to deal with in the past, and we'll compare that to what we have to deal with now to try to get some clarity for us here in the European Parliament as to how to deal with this matter. Now, this is something that we consider to be extremely important to protect and defend the interests of those working in this field, but also to ensure the quality of services provided, to ensure security and health within the port environment, and to not let that be undermined. In the group, we had already discussed this issue. We discussed the fact that all of those who wanted to invite guests from their member states would have that opportunity. And I'm very pleased, therefore, to see that we've got a broad level of participation at this hearing. We've got people who are not just active in the very specific fields of work within the ports, but also people from the broadest scope of countries from the member states. That means we'll get a good level of feedback right across the countries of the member state, and we can really build an EU picture, not just a picture that represents the individual characteristics of an individual country. Now, I'd like to thank the organisers expressly for having put together this initiative. I'd also like to thank Dimitris Kirogiktis expressly, because I can imagine that it's not all that easy to get involved in this discussion at this level. I'm also very interested to hear how he presents the forthcoming package. It is a good opportunity to hear from the Commission. I think it's a good thing for the Commission to have this opportunity to present the proposal. He is a department head in the field of ports and inland waterways. Now, in the group, we invited Portuguese port workers to come and talk to us, to tell us about the situation that they find themselves in, how they are trying to fight against the closure of ports in their country. We also had an online petition on our website relating to Greek ports, and we think that harbours and ports have a lot in common. There is a link between the different countries right across the continent and between the people working in these fields to try to defend ports and harbours, and I think that's something that the Commission has to take into account in its proposals. So that is why we really want to put in place very high standards in terms of security to ensure that the workers in ports and harbours are protected, and that we're protecting people in the various different fields of work. Now, this is the third time we've had to deal with a proposed liberalisation. I can remember very well the second approach to liberalisation, which took place in 2006. There were a number of demonstrations of the Hamburg port workers in Strasbourg. I was there as well as part of the group and my delegation. We managed to get a good insight as to just how mobilised the port workers were and able to demonstrate. Also, we heard extremely clearly their arguments. We heard just how eloquently they could argue their case, and we learnt at that time that it's extremely important to address the question of liberalising port services from the perspective of the people who work in the field. So once again, it's not just a question of making sure port services are done in a certain way. It's essentially, first and foremost, about the people who are affected by the changes. And that's the people that we should be sticking up for. We've got social standards, we've got working procedures within ports that have to be defended. And I think this is a key part of our life together in the European Union that needs to be defended. Now, a lot of the Commission's proposals in the past have been rejected, and second time around I was quite surprised that there was a majority against the proposals by the Commission. And I can remember that a lot of the members of Parliament felt that they had to shift their opinion because of those demonstrations that took place at the time of the proposals coming out. Now, what we want to do is send a very clear message to the Commission. We believe that freight processing in ports cannot be subject to the free market. We think that safety provisions, particularly for piloting dredging and port harbouring services need to be dealt with separately, and we also think that public investment needs to take place in order to ensure that the ports develop properly. We believe, and I'd very much like to hear the Commission's view on this, that the new attempts by the Commission to come forward with these liberalisation proposals are incomprehensible, because we think that there have been agreements arrived at in the past which would be undermined by this proposal. Now, trying to replace the public services with the private market in member states is no solution as far as we're concerned in terms of improving, creating, ensuring jobs, making sure that the standards are defended. We are members of the European Parliament, and I believe that this is something that goes beyond our political group. So I think we will get support for this across the board, but we think this is a question of employees' rights, so the unions will be on board as well. We think it's important to make sure that social and technological developments happen with public investment in place. Now, that's why we will be sticking to our guns and trying to make it very clear what we think and bringing this debate forward in the Parliament. That's something that we will certainly drive forwards, but we are very pleased for your presence here, that helps us to do it more forcefully. So we hope that this debate is successful. I do have to tell you that just before 4, I will have to leave the debate. It's not because I'm not interested, but I have to be elsewhere, but I will be following the debate very closely from afar. So I'll leave it in the capable hands of my colleagues from there on.
Thanks, Gaby. Now the introduction on the item by Sabine Wills. We have got the procedure here. She is the shadow rapporteur for the GUE/NGL group within the Transport Committee, for our group.
Ja, vielen Dank.
Thank you very much, Roberto. If I may, I'd just like to set out a few of the basic positions of the left-wing group in the European Parliament, and if I could just tell you where we stand on the Commission's proposals, and to give you a few most recent developments from the Shadow Rapporteurs meeting. To begin with, the European Commission presented this liberalisation package on the port services to try to bring in the private market. We think that it is superfluous. We reject it, therefore. I'm sure you're all aware as well that there has been a Porteous study which demonstrates that 80% of those asked was satisfied with the way in which port services were being done. So there is no need for additional regulations or changes. We've also submitted an amendment or a request to reject the Commission proposal, but we've also submitted specific amendments to certain portions of the text, for example, to improve the rights of workers. The legal form that's been chosen, a regulation, that is totally inappropriate. It would be then applied directly to the member states, and there would be no margin, as there would be in a directive, to shape things as the member states see fit. And we think this legal format is not appropriate because there are differing conditions in the differing maritime ports within the European Union. And of course, those member states would have to take into account those differing situations. We've had a hearing with various different port services in the Transport Committee over the last few years, and that's been extremely useful to demonstrate that a directive would be the best legal format. Now, as far as we're concerned, the liberalisation proposal is in the interest of the boat owners, as were the first and second attempts at pushing forward these proposals. We do not share the SPD rapporteur's opinion on this matter, namely that the increase in port services across Europe will be better served by this kind of liberalisation. We think there will be an increase in this kind of attempt over coming years. We've also seen the Port Package 3 that the Commission is going to come forward with. If we look at the scope of application of the regulation, as far as I'm concerned, this is completely against the whole system, because dredging, mooring and the harbour services, as well as piloting services, would be covered completely by this regulation. And we think that these should be removed from the scope completely. As we've said already, we're just a small group, but whether or not we get support for this opinion will be seen later on. We think, for example, that piloting services are part of the sovereign services within the German coast, so this is something that has to be considered a sine qua non for ensuring vessel security in Germany, and therefore can't be considered simply as part of a commercial operation. Dredging is also an extremely important service in the general interest and can't be considered a market operation. This is something that Mr. Fleckenstein has been considering within his report. Now, if the Commission proposal is implemented as it stands, we believe that quality and safety would be undermined and jeopardised. I've already spoken a little about the negotiations to try to find a compromise with the rapporteur and the other shadow rapporteurs from the different groups. According to recent developments, only dredging will be removed from the scope. Harbouring services and pilot services will still be in the scope of the regulation. We believe that this is completely wrong. We're also particularly shocked by the proposals in Article 8, Paragraph 6, which is to limit the right to strike. This was something that was attempted in the processing of the first railway package through the Monti II strategy, which tried to ensure minimum services in times of strike. In the Port Package 3, the EU Commission wants to set up emergency measures to empower port authorities to use other operators. That means that strike breaking will be legitimised, and let's not forget that the right to strike is a basic right. Together with the ETF, the Transport Workers Federation, we believe that this has to be clarified. Strike should not be considered a trigger for emergency measures being taken. We'll be submitting an amendment to get clarity on that. In fact, we've already submitted that. In the compromise negotiations, it's also become clear that other groups support our approach, and Mr. Fleckenstein has taken that on board. At the moment, however, there is a slight difference that's being mooted among the shadow rapporteurs, which we believe on this question of the right to strike undermines our position, and we don't think it's acceptable. And I would call upon the union representatives here to work together with us to exert further pressure to make sure this right to strike is maintained. I'd also like to talk about another series of problems relating to port services. In the draft proposal, the directive on awarding contracts is mentioned. The Commission talks about opening up to the market. Public contracts are to contribute to the EU GDP to the tune of 19%, and that, according to the Commission, is going to be achieved through greater transparency in the awarding of contracts, concessions particularly. That means that public authorities are supposed to achieve an optimal cost-use relationship, but that means that there will be greater business opportunities for businesses in the European Union to get into port activities. And we think that the European Union is not really taking proper account of proportionality in its measures on the awarding of concessions, and it's not really clear how this is going to affect municipal administrations. We think it's very important to acknowledge that this Port Package 3 is not isolated. It's to be seen together with the other EU Commission proposals. There's a neo-liberalisation, privatisation and deregulation that's part of the EU strategy, and it's actually been enshrined in the treaties from Maastricht to Lisbon, the rights of workers have been degraded, and as have social standards, and the quality of services and products has been affected. And I'll say it very clearly, on the basis of the Lisbon Treaty, competition policy has taken centre stage, and there's no social, peaceful and democratic EU policy making anymore. In terms of the time frame for negotiating the proposal, the vote is to take place on the 11th of February 2014 in the committee. In negotiations with the shadow rapporteurs and the rapporteur, it's become clear that we still need to talk, we need to negotiate, and that means that we're going to have to postpone this before it can come to plenary. However, the vote still has to take place in plenary during this period of Parliament, so at the latest by mid-April. What that means is we have a lot on our plates, and with a view to the speakers that we're going to hear this afternoon and the people who are present here who work in the field, we would draw upon your practical experience, and we need your support in demonstrations to the European Parliament. Thank you very much.
Thanks a lot, Sabine. As you listen, everybody will have a debate open with all the groups. So the debate is ongoing. The Trunk Committee is ongoing with the social stakeholders and whoever. And now we are here to influence this kind of decision-making process and let then give the floor to the other panelists and then up to everybody. So here now we have Demetrios Theologitis, that's head of units of the port and harbour in the DG MOVE of the European Commission. And please.
Thank you very much, members of Parliament, ladies and gentlemen, representatives of the associations, of the European associations. It is a pleasure for me to be here, and I was actually delighted when I received the invitation. The reason is that we have never moved away from dialogue. All through the process, which has lasted for years, we have held an open ear for everybody who cared to speak to us, and we have also ourselves been to speak with many of you. It is not a coincidence that most of the persons around this table we have already discussed, and we have had the opportunity to have an exchange of views. Maybe the result is not exactly what you were hoping for, but of course you must understand that we are there to give a European solution which could be as much acceptable as possible. It may come as a surprise to you, but we actually agree on many points that have been raised up to now, both by Mrs. Wils and as regards the announcement of this conference. Of course, it has not entered our mind, for example, to lower any safety or social standards. This has not been the purpose of our exercise. Indeed, what we wanted to do is create the conditions to raise safety and social standards. And I will be coming into that very soon. Maybe we need to catch up a little on the communications that we have made. This has been perceived as a liberalization exercise. It is actually not a liberalization exercise. It is more an exercise to frame the port services, many of which have a public character. And this has been our great effort in the first part. In the second part, we are talking about the transparency. So allow me to make a few points. I will not go through a sterile description of the proposal, which I'm sure many of you have already read. So I will not go into this exercise. I would just like to raise a few points. First of all, we have learned from the past, from the Ports Package 1, from Ports Package 2, as it is called. We have in the meanwhile issued a communication in 2007, which unfortunately did not have much effect. When we started in 2001 and 2004, indeed, the purpose was liberalization. You have to imagine the Europe as it was then, where we had gone through several liberalization exercises in aviation, in airlines, in the road transport domain, in the shipping domain, in inland waterways, and it was then only natural to continue on to the ports. Now, today, the purpose is completely different. Europe is going through more difficult times, and the purpose of our exercise is to contribute to the creation of growth and to the creation of jobs. This is what we wanted to do. And by doing this, with these new policy goals, we hope to create legal certainty. We hope to attract investments in ports, which in the end will create more jobs and more growth. We hope to promote the social dialogue between the social partners, and we have created a committee on the social dialogue. Many of you participate in this committee around the table. And last but not least, Europe is prepared to spend tremendous amounts of funding on its transport infrastructure. This funding is public funding. It has to be spent in the best possible way according to rules and procedures which will have been agreed in the democratic process. So this is a very important part. The 32 billion which have been earmarked from the Connecting Europe facility for transport need to be spent in your interests and according to the rules that we shall define together around these tables of the Parliament and the Council. Therefore, we do not see this exercise as liberalization. And if you look at all the conditions and at the toolbox we are proposing, in fact, what we want to do is clarify the framework for the provision of port services. What we want is to recognize also, wherever necessary, the public character of some of the services, and then organize this public character so as to give legal certainty to those actors which need this in order to grow further. Also, we want, as I said, in the transparency domain, to make sure that your money, the European taxpayers' money, is spent in the best possible way and according to rules which have been agreed amongst us. Another point that I would like to raise is that we have steered, yes, you have seen it very correctly, we have steered clear, we have not included port labor as one of the subjects we are treating. And there are good, very good reasons for that. First of all, there is the history of the past. We would not want to go into, again, a sterile exercise. And for that reason, from the many instruments, there is no problem in saying so. And for that reason, we have created, and we have been working on it since 2008, the Social Dialogue Committee. The Social Dialogue Committee involves the social partners. It has already started working. It has met 3 times already, and it is ready to move on. It has as subjects the most important parts, which are health and safety and training and qualifications, and also some other accessory subjects. We are very hopeful that this will continue. I can assure you that there is no hidden agenda. You may say, and we have heard it, and you have expressed it very clearly to us, well, now you start with an exercise which does not touch labor, and then once this is done, you move on, and then you will come with a proposal which will include labor. Why should we do that? If we achieve the goals with this instrument, if we have a social dialogue, why should we go to an exercise, through an exercise which is extremely time-consuming, and an exercise in which you will have the possibility to intervene again? As you know, the Commission, when it creates a new proposal, it has to go through a process, and this process foresees consultation, foresees impact assessment, foresees a lot of instruments which make it quite cumbersome, as we have it now. So you will have all the time in the world to intervene, and you will know about it. But it is not our intention to embark on such an exercise. We feel that we have enough on our plate with this. Let us work on this proposal, and then we see about the rest. Thirdly, I would like to say that this proposal is moving in a direction which is actually a safeguard for the good systems of port organization. In particular, with the work which is being done by the rapporteur, Mr. Fleckenstein. I understand you do not agree on everything, but you must recognize that the proposal has moved into a very clear direction. It is now safeguarding many social rights. It includes all the necessary clarifications in order to make sure that those social rights are really safeguarded and the public character of some services is safeguarded. We will be open to these amendments and we will certainly move with you to that direction. As regards the right of strike, I would like to clarify something. The reason why we have foreseen these measures is the following. Since we accept exclusive rights, since we accept situations where there is only one service provider, what we wanted to do is foresee the situation where this service provider is not able to exerce their duties. They may go bankrupt. They may decide to leave the domain. They may say, well, this is no longer profitable for us. And since we foresee a procedure for the selection of these service providers which have exclusive rights, we cannot leave the port sector, the particular port, without, say, pilotage or without other services for 6 months until the new procedures are made and the new contractor is being chosen. For that reason, we have foreseen these emergency measures. It was very far from our thinking to start discussing about strike rights. Strike rights are in the Charter of Fundamental Rights, and there is no legal instrument which can go against these rights. So, if there is a need for clarification, and apparently there is, we will be very happy to accept it in order to clarify that strike is not within the scope of what we are trying to do. So this we can very well follow, and we will be working with you in order to make it as clear as is necessary that we are not attacking the right. Finally, we're working on the provisions of the good use of public funding in ports. The famous transparency is, as I said before, about safeguarding your taxpayers' money. This is quite clear. If someone receives public funding, and we have never said anything against public funding, and as you know, whenever there have been cases of state aid in ports, the European Union has nearly always judged in favor of the state aid. So there are indeed situations where ports need absolutely public funding. So for that reason, we have come up with all these clauses about transparency. Otherwise, if we said, well, there is no public funding possible, we would not need that. So the very fact that we are foreseeing this transparency guarantees that we are in agreement that there are situations where public funding is necessary in the ports. Finally, I will conclude with a word on safety. If anybody can accuse the European Union of everything, it is that we overdo it in terms of safety, not that we ever try to lower safety standards. Take shipping. If you make a list of the safety regulations in shipping, you will see that there are pages and pages just of the titles of the necessary legal instruments. So if there is ever the slightest suspicion that the text is not guaranteeing the safety, we will be more than happy to rectify it because it is very far from the direction we have followed over the years. Finally, I would like to say that this proposal has many advantages. It protects the public port services from legal uncertainties. It should protect safety. We will be working on that. It protects stakeholders from unfair competition. It will help the growth and the jobs which are so much necessary. And of course, it will contribute to the funding in the ports together with the rest of the infrastructure that we are doing in the Trans-European network and the guidelines. We believe that the port services are safer in the regulation with a good framework, which we will have all decided together, than to be at the mercy of any complaint or of any local court which may decide one way or the other. Thank you very much.
Thanks a lot. I think we have to go and hurry up with the intervention. So the floor will be to Rolf Frisch, the former Hamburg Port and Logistics Company Labor Director from Germany.
Ja, meine Damen und Herren,
Ladies and gentlemen, can I begin by thanking you for giving me this opportunity to address the meeting. Now, I don't want to abuse this privilege, but I'd like just to say a word about a widening out of the competences. No one doubts that there is such a thing as market integration and liberalisation of the market, and that this has brought greater prosperity. Clearly, this has given an impetus for growth as well. In recent times, however, the efforts by the Commission to take unto itself further powers and competences have brought it criticism. The criticism is not just coming from the trade unions, but also from the left of the political spectrum, from academics, and also writers and culture critics as well. You remember President Martin Schulz's speech at the time of the award of the Nobel Prize and the criticisms of the Commission at the time. President Schulz has given interviews to the Spiegel and in the Süddeutsche Zeitung, and only recently at the SPD nomination conference, when he criticised the bureaucratic excesses of the European Union, and he reminded everyone that the principle of subsidiarity is on the statute books and still applies. Now, it seems to have dawned on him rather late, now that there are 28 member states in the Union, and I think that everyone should look at their own conscience after all this time. But Knut Fleckenstein, I'm not sure that it was ever going to be possible to bring all of these things together, all these strands together. The conflict, however, which has surrounded the Commission proposal, might help us get a proper framework for market access to port services and financial transparency. Not that the internal market is more than tangentially affected, but clearly there is bureaucracy and centralisation which are becoming ever more pronounced. We have mentioned the second port package. There was a double negative result in the votes, and the Commission drew its own conclusions. In 2007, the Commission stepped back from the proposals regarding European ports policy, and they said that in future they would only use the existing primary law, in other words the treaty, and not binding soft laws to tackle breaches of competition in the European seaports. As a further locomotive for growth in 2013, the Commission has not been looking at measures which were not binding. But if you look at the analysis going back to 2007, it's really half a page of foolscap. And I think that the analysis has not been very meaty. At the time, the ports were hailed as a vector for growth that they failed to deliver, and a draft regulation was the response to that. Now, what is the reason This is already set out in the primary law. There is scope for a change of the option, but there is a need to provide justification, to provide reasons, if only because of the need for legal certainty for the parties concerned. However, that is lacking, and that's really dismissed or commented on, touched on very lightly in one sentence in the explanatory memorandum. Now, a draft regulation should be fully backed up. There are the principles of subsidiarity and proportionality. The subsidiarity protocol is number 5, is there, of course. The financial impact is also nowhere to be found. The legal requirements, the need for a balance in the measures leading to the objectives. Again, just a few sentences there. It's touched on very lightly in the explanatory memorandum. And there are different kinds of action, regulations, directives to achieve the objective. The Commission must look at the different formats and go for the ones which are in line with state powers, and they must properly respect national sovereignty. That the Commission has failed to do. It doesn't justify itself. It doesn't give reasons for the legal format. And so it's a little bit thin. If the reasons are not given, if the legal options are not set out properly, then this is in breach of fundamental things, and this leaves the legislation open to challenge. In 296, Article 296, it states this out very clearly. Now, you might say that this is a framework. This is a framework, and you perhaps wanted a regulation and a binding regulation which would not leave the member states any margin for manoeuvre. One has difficulty now in understanding how this could all have come about. The draft regulation has a range of deficiencies and flaws. For example, if you invoke directives, regulations, the concessions directive, without them being on the table. If you analyse the text and try to get to the bottom of it, then you've got to be able to follow all the references, and that was not possible at the time when this was brought forward. Now, on the substance and on the scope, some of those services are in breach of the law, and yet they've been brought in. For example, tug services and piloting. I think you have to accept the fact that there is case law now in the Court of Justice, and they have said that where port services, there are safety and environmental reasons why they cannot simply be thrown open to competition, and because of that they cannot be incorporated into the regulation. They are already dealt with elsewhere in other regulations. Now, of course, in piloting, of course, again, that is covered by case law in the Court of Justice. And the tugs as well apply, as do the moorers, the mooring operations, and it doesn't really leave very much. And I think, in consequence, you might want to ask whether this requires to be regulated and covered again when it's already looked at. Competition between ports is working. There's mention made of surveys, and the draft regulation does not open up any further margin of manoeuvre. What it does is it squeezes existing margin for manoeuvre. For example, 2 port operators must be involved, it says, with infrastructure charges. It says they can only be collected for a particular reasons, and they have to be variable. And this is in restriction of competition. And the criticisms of that have been, I think, deafening, and I hope that the Commission is listening to that. Another thing which looms large is economic freedoms and fundamental rights. In other words, labour rights. Again, there is settled case law in the Court of Justice in this connection with regard to labour laws. Economic freedoms are absolute here, and they take precedence over fundamental rights, and that surely is not possible. Certainly under German constitutional law, it sets out in very clear terms that the fundamental right has to be given there on an equal footing with the economic freedoms. We may come back to that. And the added value is difficult to find. This is a parallel structure which is going to run into money. There would need to be a legal supervisory body. That, again, would cost money. And it says somewhere that this would make an annual saving of $1 billion, and that has been simply pulled out of a hat. This also interferes in the federal structures of Germany. You cannot have that kind of parallel body which has a coordinating role. That really doesn't stand up. The system is supposed to be able to evolve and to improve over time. Now, I don't think that the system, as described, if it does work, then I think that it ceases to have a raison d'etre. It doesn't have any talk about a midterm review or a review clause at all. Now, one or two conclusions. There is mention made of a PwC study on quality and efficiency of European ports. Well, that really is garbage. You can't really, the level of the research there would not would not pass muster with first year students at university. Really very shoddy work. Conclusions which do not follow on premises which are extremely sketchy and flimsy. And the Centre for European Policy Studies itself says that this does not stand up, is not justified, and it raises expectations which it cannot deliver on. I believe that there's a lack of coordination, there is no stand-back overview, no systemic rationale. This second attempt, the second bite at the cherry of regulation, is again a failure. And I don't think that it can be improved, and one would only be tinkering with it at this stage. I believe that the entire draft is simply beyond redemption. It's in conflict with the subsidiarity principle, and I think that I would need to agree with President Schulz in that regard. So far, we have not seen the improvements we expected in the wake of Lisbon, and I think that in political terms this is deeply unsatisfactory.
Going on with the intervention, we have now an introduction by the European Transport Federation by Mrs. Livia Spera, representing the ETF here in Brussels.
Thank you, Roberto. Good afternoon, ladies and gentlemen. My name is Livia Spera. I'm Political Secretary for the Docker section at the ETF, the European Transport Workers Federation. For those of you who don't know us, we represent more than 2.5 million workers in 41 European countries in all transport modes. I would also like to thank the GUE NGL group for having organized this hearing and for having invited the ETF to express our opinion here today. We have, the ETF has opposed, has expressed a clear opinion on this regulation, as opposed to this regulation, already since the consultation process that preceded the adoption of this new legislative package. We have expressed a negative opinion on the measures proposed, or at least on some of them. We believe, first of all, that to judge this proposal, we have to frame it in a wider context and to look back at what has happened over the last 15 years. Just to be brief, because I understand we have a limited time, we first had the Green Paper, then we had 2 directive proposals, which were mentioned by the previous speakers, which we usually call port packages. There's no need, of course, to recall the wide opposition to the port packages, not only from the labor unions, but from other parts of the industry as well. The two proposals were, as it has been recalled, rejected by the parliament. And then the idea of soft law approach was launched by the communication in 2007. And according to the Commission, as Mr. Theologitis just recalled, this approach did not work. In our opinion, the approach was never fully pursued, was never fully explored. So it wasn't given much chance for it to be implemented. So now, today, in our analysis, there is another port package. It's coming under a different shape. The regulation proposed contains in its chapter 2 measures that were already included in the port package. The impression we have, and we have already said this in the past, is that it was decided to start over the process by tackling the least controversial items, which is the market access to technical nautical services. And as I said, we are here today to state our opposition to the, we do not want to call it liberalization, we call it opening of the market, or whatever you want to call it. We are here to state our opposition to this, and why? This for several reasons. First and foremost, technical nautical services are, for us, services of general interest that are critical to port operations and to safety. Maybe we are sure there was not the intention from the Commission to jeopardize safety by presenting this proposal, but certainly, in our opinion, that there was no real assessment of the consequences that this proposal would have on safety. In our opinion, these services, and especially pilotage, mooring, and towage, should not be open to competition, because this, as it has happened in other sectors, and as it has happened in this sector, in some countries where they were open for competition, and I hope that some of our members that are present here today can present their cases during the debate that will follow. It has resulted in a race to the bottom, where the cheapest option prevail, and not the general interest, as it should be the case. As a second point, we do not see a sound rationale for this proposal. We do not see an added value for this proposal. If we say that all the other transport sectors have been liberalized, well, we say that's why we do not want to be open to the market, because we see that working conditions in the other transport sectors are being lowered following the opening of the market or liberalization of privatization processes. One of the declared objectives of the Commission with this proposal is to improve the efficiency of European ports, and we do not see how opening the market for technical nautical services can actually contribute to reach this objective. We cannot deny that there are efficiency problems that affect some European ports and not others, but the question is, do we really need European legislation for tackling this? Why not going for local port policy tackling the actual inefficiencies of the ports, of those ports that are underperforming? Inefficiency, where it exists, is not in our view depending on European legislation, is rather depending on wrong political choices, political policy choices that have been made in the past. As it was reminded also by the previous speakers, the surveys that were commissioned by DG Move previous to the presentation of the proposal in the framework of the impact assessment showed that there is a quite significant satisfaction among the users of the services in question. So this is another element that that explains that there is no sound rationale for this proposal. We do not share the general approach. We think that, once again, there is a dogmatic approach that has been taken, according to which opening the market equals to improve the efficiency without taking into account all the other variables that are present in the sector. Our question is: are we really looking at the reality of the technical nautical services in the ports? Because if we look at the situation in the different ports, which are very diverse, of course, we see that even where there is no market access, there are many examples of arrangements already in place to guarantee, for instance, transparency of prices or involvement of stakeholders in decisions that concerns investments or other aspects of the management of the technical nautical services. We do not believe that there is the economic viability in many of these services and in many of the European ports to have more than one operator. We are not here, and we want to be clear on this because we have been accused of this sometimes in the past. We are a federation of trade unions, and we are not here to defend the interest of or the right of private enterprises to be the only players in the market and to abuse the situation of monopoly. We are not here for this. We are here to state our doubts over the fact that such limited specific markets that also require huge investments and specific know-how, as are those for technical nautical services, can be open to competition and can guarantee at the same time economically viable enterprises. For us, as representative of the workers, is fundamental that the enterprises that enter the market can guarantee continuity of employment, can be, from the economical point of view, healthy. If we add another operator in the market, we will not create additional jobs because the market share remains the same unless, of course, the port develops its operation. So was there, before this proposal, really an economic analysis to show that there is space for new entrants, that there are potential investors interested in the sector? So these are all questions that we should put on the table. Then another, of course, important element for us is that the social dimension in the Commission proposal is weak. It is true, compared to the past, there are some provisions. So if we want, we can also consider this as a step forward, but this is certainly not enough. What it was said before in the opening speech by the president of the GUE group is very important for us. We first have to be concerned about the people who will pay, we are concerned by the fact of the legislation that is being proposed. If we mention, for instance, Article 10 on the safeguarding of employees' rights, this is not enough to counterbalance the effect that the opening of the market would have on the workers. First of all the measures proposed by the European Commission are optional. So, in fact, they do not impose anything in concrete. Secondly, we know that the instruments that are mentioned, for instance, the directive on transfer of undertaking, is itself a quite weak instrument. So the article itself, as it was tabled, does not present a big improvement, let's say. There is this article that was mentioned before, or this paragraph that was mentioned before, that could limit the right to strike. If it was not intentional, then we are very, we encourage the debate in the Parliament, the MEPs that are involved, to change it. Some amendments were proposed that go in the right direction. We believe that the good repute of the operator should be put amongst the conditions that the requirements to enter the market, and that this should be made compulsory. This is a provision that already exists in legislation, for instance, on road transport. It's something that is included in a proposal on the European Maritime and Fisheries Fund that was voted yesterday, on which was reached an agreement yesterday by the trilogue. So it is not something new, and it is something that would guarantee that people who don't, or enterprises who do not respect, or who have an history of not respect for labor rights, are not granted access to the market. So we recognize that legislative process in the market is trying to improve the text. Many amendments have been tabled that go in the right direction, according to what we believe. But it also seems that at the moment the debate in the Parliament is stuck, that it's difficult to find shared solutions. What we are certainly firm on one thing: social condition cannot be an option. So as far as social conditions are concerned, we cannot have may require. We have to be certainty that workers have certain guarantees. And then just briefly on transparency, we are of course in favor of increasing financial transparency, especially when public funds are involved. Our question is, are the instruments already in place, the general horizontal instruments already in place, also those related to the allocation of public funds, not necessary, not enough, sorry, to guarantee financial transparency? So is their application to the port sector not enough to guarantee financial transparency? Do we have to establish another mechanism from scratch? Just to conclude, and going back to the start of my speech, we feel this regulation has to be framed in a wider context. It is true it doesn't contain provisions on labor, dock labor. It doesn't contain provisions on self-handling or on cargo handling. But it is also true that the same objectives of the Port Package 1 and 2 are being pursued at a different level. They're being pursued at national level. If we see what is happening in Portugal and Greece, where restructuring plan or privatization plans are being imposed by the Troika.
And to a large extent, the question has to be asked, what's the great need for another round of attempts at liberalisation? Because it does not seem that there's a demand for it. And I believe that what's important is the quality of jobs in ports. This comes under social dialogue, which is advancing, not quickly, but it's there and it's moving forward. And the attempt here is to change the atmospherics which surround the dialogue between the social partners. I think that we must look at this at national level rather than EU level. If you look at the pressures to change the working conditions, look, for example, at the port infrastructure. In Portugal and in Greece, the Troika has directed its attention to the situation in the port. We are now working under conditions in Greece which have been imposed under the memorandum and are dictated by the Troika. And this is now affecting small regional ports. But they've not been applied to big ports such as Piraeus and Thessaloniki. In Portugal, the approach has been one-sided. It's been unilateral. The labour conditions have been changed in a unilateral way. Again, because of the pressure from outside and from the Troika. And this is not to the benefit of those concerned working there. What it does is create downward pressure on wage levels. It means that the middlemen and the intermediaries are able to gain profits at the expense of people's lives and life and limb, and also their security and safety. In Piraeus, for example, we have a new phenomenon for European ports, and it's called COSCO. Quite apart from the downward pressure in terms of working conditions, I believe that we are seeing a form of state aid which is being now happening. And the COSCO terminal involves subcontractors, and there is a complete disregard for fundamental protections. It means that there is no training. The working conditions themselves have suffered, and standards of safety and health have also suffered. Another way that working conditions change in ports is the case in Spain, with the so-called justified reason. Now, even though we had legislation which had the support of the vast majority when it went through the Spanish Parliament, despite the fact that there had been unanimity in the legislation, now all of a sudden we are seeing changes imposed, foisted on those concerned from on high. If this goes through, then it means that we will no longer have a framework for discussion, and it's going to squeeze any margin for manoeuvre. The ports are going to be regarded as being monolithic, one-dimensional, and they're going to be there at the whim of the big shipping companies and the users. Now, the attempt at allaying the fears of the different stakeholders has meant that it simply touches on things which have not done justice to, for example, economic transparency. It does not do justice to the environmental dimension, and it simply refers to the, when it comes to working conditions, it talks about other pieces of legislation, such as the concessions directive and the situation applying to workers in the event of the transfer of operations, the transfer of companies. And I think that there is a general drift in this. The reason is that the only benchmark has been the economic factor, the economic cost. And of course the economics of ports is very complicated. It's not just the port management. Ports are not just or exclusively a link in the transport chain. Of course, that there is such a thing as the transport chain. It is working perfectly well. What's happening to the local economy? If you have a port which has local conditions, that is the appropriate level. An important part. This is an important part of the treaty. The local authorities should be properly involved, and under this regulation proposal, that it will no longer be the case. Quite apart from transport, ports have important public administrative systems, and who is going to be responsible for them, particularly at a time of concessions which are still undecided, unresolved, certainly as far as we are concerned. The ports can give leverage for growth in the areas which they serve. They are connected to other economic units and are part of a broader pattern and a broader area. And this is important, of course, for those engaged in administering the ports themselves. Who is running a port is very important. And it's not possible for provisions which are suggested to have the administration at the centre, to the exclusion of the local communities. The people directly concerned, the communities, should be involved. Now, for reasons I do not intend to go into at this point, the local population must have a conduit for their views, even when it comes to matters such as external affairs and defence. The ports are big employers. Conditions which apply there affect people concerned and their families, but also the economy of the wider region. Now, when it comes to the shipping companies and the managers of the management of the infrastructure, their concern is clearly the profit margin. They're trying to drive down prices at the expense of the employment dimension. I believe that safety and health, full employment, collective agreements, all of these things are regarded by some as being luxuries which simply increase the prices. I come from a port where Costco is a real laboratory, a textbook example from which we can learn. The Greek government at the time was constrained by the memorandum, and Costco has no intention of entering into negotiations. The government has not dared to make the requirements, to impose requirements which are one might expect from a sovereign state. So Costco is able to conduct itself with high levels of insecurity, low wage levels. And just one word on the environment, if I may.
The other speakers.
Ports, of course, do impose environmental burdens, and the environment has to be protected. And the people who work there, the population and the workforce, must also be involved in that and must be allowed to participate. But that must be within a clear and transparent framework. And the management must be cognizant of this dimension. I don't think that when it comes to the maritime policy area, I need to go into greater detail. Clearly, there is a big demand for cleaner fuel. Transparency of funding is an important issue, and the instrument proposed here is purely competitiveness driven. And I believe what will happen is that there will be monopolies or oligopolies. And the question then is, what are the criteria which have to be looked at? Are we going to see one kind of monopoly basically replaced by another kind of monopoly in the transport network, if it's in the same corridor or linking countries in the south and, for example, linking countries to the north? There are regions which are external borders, and this is something else which I think needs to be part of the overall picture.
Thank you. Now, Anthony Victor, who's coordinator of the European Zone of the International Dockers Council.
Bonjour.
Good afternoon. On behalf of the IGC, I'd like to thank you for this invitation to speak to this legislation, and especially on what is going on in European ports today. Firstly, I'd like to point out that the IDC only represents port workers of the handling section in ports, so my contribution will be more focused on that rather than the other sectors, even though we still can see that we must oppose this new legislation. I'm going to respond to Mr. Teologidis saying that there's no social dialogue problem, that every time we've asked to speak to them, we have been received. But for us, social dialogue isn't just sitting around a table and discussing things and then keeping things as a status quo. We need to get things moving. And unfortunately, when we came to speak to the issues that I will speak on afterwards, when we did it, since that time, we still see no progress. The European Commission's change on their position on whether to tackle handling in this new legislation was not changed because of social dialogue. It's because European dockers were able to get mobilized, and they actually threatened to act as they did in 2003 and 2006. And we are convinced that it is that which made the Commission change their minds. Otherwise, the dockers would have been covered by this legislation. We're very convinced of this. Now, when we learned that for the third time that the Commission wanted to legislate the organization of labor in this sector, we got together and said that we would fight this new legislation coming about. Now today, even though we can see that though this legislation is not going to influence port handling, we are very mindful, and because we very clearly made it known that handling would be withdrawn from the legislation, but they would be very mindful as to what happened in the Social Dialogue Committee, and if by 2016 things hadn't developed enough, that the Commission might revise their position. We joined the Social Dialogue Committee to get things moving to the advantage of ports, all ports, harbors, and also from the company standpoint, but also for workers' security and safety, and the quality of work to be done. Now, as I was saying, we joined the Social Dialogue Committee to make sure that all European ports could be developed and have their performance improved by quality work of workers from the qualified professions, and that this work should be carried out in safe conditions. We deplore the fact that European policies which have been imposed in certain countries actually are counter to the job that we've been trying to do in the Social Dialogue Committee. Despite different interventions, the policies actually we see that very high-skilled dockers are being made redundant in favor of lower-skilled dockers whose situation for security and safety are not guaranteed, nor the quality of work. We talk about transparency, but we're not seeing any transparency about the unacceptable working conditions in which certain dockers must work. The ultra-liberal policy led by Europe and imposed upon by the Troika to serve the world capitalistic system is seeing a real social worsening of dockers. A flagrant example is what is going on in the Pirangas port, and our Portuguese partners are living through a catastrophic conditions. For competition reasons, dockers have really seen their rights shattered, and they're seeing people who are being hired in precarious situations who are very low skilled, receiving about a third of the proper wages. And of course, liberalization is not promoting the interest of the workers or the member states, but the main financiers will try to get a royal position in Europe and to defend their interests, like in Costco in Greece. We deplore these risks which are coming about and that the member states are creating, and rather than creating wealth and jobs, the situation has lasted too long. These liberal measures have been in power too long. We need to come back to social measures in general interest and not just individualistic type of legislation. There are certain types of trade union discrimination situations in ports. The losing out on the right of strike is an unacceptable situation, and trade unions are the only way to get wage earners' rights defended. Now, when we talk about trade unions, in trade unions social dialogue, if there's true social dialogue, there's no fear that a certain profession should have the monopoly on a certain port. When we talk about social dialogue, we are really looking to achieve progress, but there has to be true social dialogue with mutual respect on both sides, which is a true guarantee for safety and to make sure that the port workers will not be blocked in an unacceptable situation, which is not the situation today. Now, there's certain employment measures applied in member states which are totally opposite what we try to achieve in social dialogue, which is to serve the interests of the entire European port community. We are still trying to participate in sectoral social dialogue, but we would like to remind the European policymakers that they must make a U-turn, a 180-degree turn, to serve the interest of the European workers who produce the wealth Only the production of wealth, accompanied by true recognition of the workers' efforts, will relaunch the economy, which is what we need today. Now, on February 4th, 2014, there will be a Solidarity Day to support the Portuguese workers, and this is a true beginning of solidarity campaigns for workers fighting for their rights and to keep their rights. We mentioned our Portuguese partners because they are really in the front line of the situation. They are in an extremely urgent and distressful, extreme emergency type situation. But there are other countries which my colleagues have mentioned, so I won't repeat those. But we really need to make changes. Now, as for European legislation, there are certain issues that need to be dealt with. Not just the financial aspect, but of course that always is to promote certain groups' interests. But we also have to deal with issues which will allow us to protect workers and let them go to work without risking their lives or being exposed to very hazardous situations with proper remuneration. That's it. Thank you. Now we've got one last contribution on piloting. This will be Maurizio Colombide from the CGL in Italy, in charge of piloting in Italian trade unions.
Va bene. Allora, buongiorno.
Good afternoon. I'd surely like to thank you for inviting me here and giving me the opportunity to give our opinion and hopefully make a fruitful contribution to this discussion. Let me start out by giving the background of the report that came along with this draft regulation. The report says that the efficiency of port services is crucial for the functioning of ports. But there are certain negative aspects. Now, what might they be? Low competition, low levels of competitivity, the possibility of developing monopolies or oligopolies, which of course will distort the market, are penalizing tool which could lead to a lack of internal coordination within the services. Now, if this is the underlying philosophy of most of the draft regulation, we might think that the Commission was inspired by the idea that more competition would guarantee greater efficiency. Now, we don't agree with this, or at least we don't agree with that. Now, moreover, in the thesis covering this regulation, there are certain common points that we do agree with. We do want to improve port efficiency. We do agree with the right to have a better traffic flow for goods and persons. We agree that we need coordination of systems, that we need sustainable mechanisms from the social environmental standpoint. But these are objectives which cannot be reached if the workers lose out on their rights. And up to now, liberalisation, which has been spreading widely, has only led to a denial of workers' rights. Now, I don't think that this is a principle which will help us improve the port systems in Europe. Now, if you look at the highly technical services, and not just piloting, of course, there are four types: piloting, mooring, and handling. And if you look at the tasks of all the people working in these sectors in a very synthetic way, the port piloting allows the ship to coordinate entrance and exiting of the ports, coordinating the ships to avoid accidents and collision with other vessels entering in the sensitive areas of the water. And
Traina la nave o la spinge nelle fasi di manovra. in avvicinamento.
Tungsten helped to open the port, and the tracker monitors the boat at the arrival. They support it when leaving until the vessel is certain to remain in safety, in safe harbor while remaining in the ports. And sometimes there is a way to establish a system in case of emergency. Now, according to Italian legislation, these services must establish a security function. There is no option that in addition to the actual service, there has to be port safety. That is something that is mandatory. And this is regulated and defined with very clear legislative frameworks and references. Now, to us at least, it seems obvious that the close connection between these services and the certain deployment of certain obligations of services makes this type of activity more similar to what we would call a natural monopoly, if you can use that term. Now, these ideas are not based on technical nautical services, but their roots are found based on technical economic reasons, which are not legal reasons. The technical reasons are linked to port safety issues. For example, there's the way of bringing the companies granting these services is something that is necessary if we want to maintain the features of the services being supplied. Now, for us, if we leave behind the idea of a single company for each port, to the detriment of port safety, would lead to very cumbersome situations with respect to the service, the quality of services. But for economic reasons, we've got to guarantee that the service suppliers must be supported, and these costs are inherent to the flow of supply and demand and inherent to market logic. So, in other words, I'm not going to bore you more with more analyses, but these analysts have found, and even people working in legal services, is there's no possibility of considering market aspects for technical and nautical services. Now, of course, the investments must be remunerated, and we've got to find the most operational way of managing these import services. So liberalization of port services, or at least what is in the report, would dismantle the whole situation. If we liberalize technical and nautical services, we would actually be threatening the safety of ports, because these services are only to the benefit of the vessels and is only indirectly linked to the goods. The idea is to maintain safety standards in navigation, especially in the ports, and even near close areas. We can't confuse that with the defense of specific corporate interests, and I hope that people aren't aiming to do that. These are ideas which would allow us to respect a certain scale of values, and safety is the first of these values. In addition, we might not look very intelligent, because opening up the market would mean that we would need a doubling of technical and nautical service operators, and this could double employment, but it would be a fictitious situation which would set up conditions which are created by a competitive system. We've got to tear things down to build them up, and there would be kind of a game to try to take on certain pieces of the market and to try to deal with the ships entering the airport. Maybe they'd have to have smaller sized ships in the future, for example. So I'd just like to say that you were talking about tariff transparency, of course. There are single companies, and of course financial transparency with respect to public spending should be guaranteed, especially for public interest. And therefore, I think that we could agree on that aspect. But still, this transparency, this financial transparency, is not, it doesn't have the basic characteristic of being able to identify certain types of discrimination against certain ships that would want to benefit from these services. And if this is one of the reasons that the Commission feels driven to make a regulation, I hope they will correct this aspect to try to solve these problems, that if they come up in the European ports, hopefully they can even prevent these problems from arising. Now, just to conclude, let me just ask you a question. If these are technical nautical services, what kind of market are we really talking about? We still haven't really understood what kind of market we could instate, but we could imagine it. For example, let me give you an Italian. Let's say you have an operator for towing service, which I was mentioning. Now, let's say tomorrow, because of regulation go into effect, you'd have to have 2 of these tugs. And so you have the the first one would have to carry 10 measures, and the new one would have to measure the other ships. So how would we actually compare the rates? And what about the quality of service, too? Now, quite honestly, I'd like to say that we've got to be very mindful. And the last thing I'd like to say is, since the users must have guarantees, I think I remember that recently the users are kind of an example of what we're dealing with here. If you look at AP3, the approval of, or the incorporation of 3 main shipping operators, and this came after the J6, where there were 6 other operators. This is giving out the signal that opening up of the market is not that helpful. And I think we're going to have to listen to that message. Thank you.
Much for this last intervention. We are going now to open the floor to everybody. You are here about around 15 nationalities. There are a lot of people who want to take the floor. We are going to mix also some intervention by our MEPs or other people who have been invited. We ask everybody, and we can have place for 20, 22 intervention, to be strict really to 5 minutes. So we didn't stop anybody before here for the first intervention, but please, you too, in order that everybody could take the floor. Our first inscription is Mr. Detlef Bade. He's Work Council of Eurogate Container Terminal Holding in Hamburg representative. Please, Mr. Bade, take the floor, please.
Ja, danke schön.
Yes, thank you very much for giving me the floor. If I may, I'd like to address a word to Mr. Theodogitis and what you said. Common dialogue between parties, that's a good thing. However, the different parties involved have to respect each other. And when you're trying to create a framework for port services and trying to get everything to work together, well, this is really a contradiction, because 80% of users are already satisfied with support with the ports. 80% in surveys. Even the normal opponents of this kind of thing in Parliament voted against the proposed packages, and they don't want to see the opening up of the markets here, considering what they have. We have good experience with the ports at the moment. You said that the port cooperation with port workers is good. Well, that's wonderful. Regarding what happened with the port package 2, why have you come back with a port package 3? We have an attempt to bring something through which is not going to be in the interest of the workers, but it's going to be a political document, particularly when you're abandoning the right to strike and saying that emergency measures can be brought in. This is not a trigger for emergency measures. We don't need emergency measure regulation to undermine strikes. We should not breach that right to strike. And so the basic rights have to be defended here. You've said that ports need to be made safer. Perhaps you're thinking that we should go along the American lines to try and make everything safer and dictate how this should be done. But I would say that we are a unified Europe. We're a Europe which speaks for itself and not just echoes what's happening in Europe. We have vessels and users which are extremely satisfied with the ports. We've also spoken to people who use ports, and for 360 days a year, for 24 hours a day, we've spoken to churches, we've spoken to people who use ports, and people are satisfied. This is, in my mind, just a joint package which is trying to push through a number of political agendas. It was the same with Port Package 1 and 2. We've learnt our lessons, and we shouldn't be going ahead with Package 3. My question now to Mr. Fritz. How do you see the situation with the strike, the right to strike, and the tariff, the wage bargaining rights? Do we have competition, and is the opening up going to degrade our social conditions or not? Thank you.
Thanks a lot. We just remember that the panelists or the other people we could take the floor at the end, giving the short reply or keeping open, of course, the dialogue, not only the social dialogue, the political and technical dialogue everywhere. Now the floor is to Antonio Mariano. He's the president of the Sindacato dos Estivadores de Portugal.
Good afternoon, everybody. Firstly, allow me to thank the organisers for inviting me to be here this afternoon. I'm not exactly going to talk about the Commission's proposal itself. I'm going to talk rather about what I think the European Union's policy is actually going to result in terms of port activity. I think essentially this is the policy that's already being applied in Portugal, and we can quickly see this being rolled out into other countries, particularly in Greece and other countries. Now, we're one of the countries where this kind of deregulation and liberalisation is underway apace. We've talked a lot about dialogue this afternoon. By the way, I'm very pleased to be here engaged in dialogue, and thank you very much for the interpretation that allows me to speak in my own language. It's very important for us to have the opportunity to discuss these questions, and I understand that the work that has been undertaken to try to engage in dialogue has been difficult, and I'm grateful for it. But these are political questions, and I think perhaps that's what goes behind the explanations that the Commission has given us. Now, I'm speaking on behalf of Portuguese dock workers, and I can tell you that what's happening in Portugal is really an attempt to make the most of the fact that we are a programme country, a troika country, the Troika has imposed a number of conditions upon us, and this has had ramifications in the port industry. There are a number of factors at play here. The Portuguese government is having to answer to large corporations that have made significant investments in ports. We've also seen systematic attacks on workers in the port industries. What we're seeing is a really decisive moment in Portugal. I'm not going to go into all of the details, the gory details of what's happening, but I will say this. There's one paragraph in the Memorandum of Understanding that was signed in 2012, and it relates to ports. It says, basically, that in the field of the dock workers, a series of services will be liberalised as a result of the reforms. This will affect dock workers in Portugal, and the government believes that most of these services will not be undertaken by dock workers in Portugal anymore. And if this comes into effect fully, it will lead to mass layoffs and redundancies of dock workers in the country. Now, that didn't actually come to fruition because the large investors that control ports in Portugal had a word to say. But following this paragraph being signed in the Memorandum of Understanding, there was a process begun of dialogue with unions. There was a real guerrilla war begun at that time in terms of the collective bargaining agreements that were immediately breached, and there was a whole fuss and nonsense that happened. Having said that, the Memorandum of Understanding was quite clear. The unions tried to stand up for what was in the interest of the dock workers, but just to give you an idea of what happened in the country, there are already different ports in the country where professional dock workers, people who've worked in the industry for 10, 20 years, are already being replaced in the country by people who have precarious work conditions, low salaries, people who don't have the right studies and qualifications, while the experienced workers are unemployed. Now, this is an attempt to completely destroy the existing organisations in the country, not just the business groups, not just the people who operate in the ports and who were once a reference point, a mark of quality in terms of port activities in Portugal. And by the way, I'm not saying that Portuguese ports were always perfect, but I do represent the workers, and I say that we've always managed to produce extremely high levels of efficiency. We have always done an extremely good job, and that is being undermined in Portugal. What I would also say is that the companies who have moved in Portugal are now trying to carry out what I would call a mass layoff program, trying to replace dock workers with alternative forms of labour contracts. As I've said, replacing people who've been in the business for a long time. We've seen successive layoffs in Lisbon. We've seen some 50 people laid off this year already. Just 2 days ago, and this is really hot off the press, another company was set up in the Lisbon port to do exactly what I've described. So by imposing a new form of labour contract, hiring new people that aren't educated or trained in any way, the services are being degraded. Now, I can't really go into all of the details in the few minutes I've got, but if we see what's happening in Portugal, we're seeing basically people are being laid off left, right and centre, and that's only going to worsen. The problem is that there are major economic groups who have vested interest here, and they're really imposing their conditions unilaterally, and they're really even imposing conditions on the Portuguese government, and the government is incapable of responding. So that's the situation we face. At the moment, there are no concerns in terms of safety. No one is breaching the terms of safety where you have to stay 20 metres away from heavy operations and so on. So fortunately, there have been no accidents yet. Unfortunately, we've seen other ports in the country where we have already seen lethal, fatal accidents in the last year. So that means that safety is on the wane, although in Lisbon, as I've said, it's not yet serious. As I've said, the economic groups that are trying to replace the trained professional workers with other cheaper, unqualified workers, that's going to have an impact. And when we see the educated, qualified people being laid off, you'll see that there's going to be a price to pay, and the wage costs are simply being cut by the economic operators working there. So that's basically all I had to say. I don't think I have time to go into any more details in the 5 minutes that's been allocated to me. I just wanted to give you an example of what's happening in Portugal. Some people have just started working in this industry 2 days ago, and I have already had the opportunity to go there, and I've asked people what the situation's like, and I've asked someone, where's the coordinator on site, where's the foreman? These people who've just been brought in, they don't even know where the foreman is. Normally an experienced worker could say, well, it's coordinator 001, he's the person responsible for this site. These people don't know that, and in Lisbon at the moment there's only one vessel that's actually operational. All the others are currently not operational, and of course this is all the result of these economic actors that have moved in. They've basically tried to get rid of the professional qualified workers, moving them out of this profession completely. This is something we've seen before. We're going to see this from country to country, attempts to liberalise and to break up the organisation and efficiency of European ports, beginning with the Portuguese ports. Thank you very much. That was it.
Antonio Mariano. Next speaker will be Uwe Jepsen from the Pilot Association, Germany.
Ja, schönen guten Tag. Mein Name ist Uwe Jepsen. Ich danke.
Uwe Jepsen, thank you for the invitation. I represent the Bundesverband of Sea and Port pilots. We have had regular contact with Mr. Fleckenstein and have tried to explain what piloting is and what pilots are. And he's certainly understood the message. He was on a tug with the pilot for 24 hours in the Bremerhaven port in Bremen, and was able to see what it's like working with those who are mooring, those who are in the tugs, and it's obviously teamwork. The tug workers and the pilots, they all work together, and they're there with the people engaged in the mooring operations, and you can't simply take out one module and put in another factory unit because of the way that they work in a team. We're against the regulation because we believe that what it's really after is already in place, certainly in Germany, and I think in most European countries. There is free access. Anyone can apply as to be a pilot. In Europe, we've got Polish pilots working in Germany. We've got Dutch pilots as well. The trouble is, of course, that they often don't want to be kind of Gastarbeiter, and they tend to revert, to go back to their country, the home of origin, the country of origin. I think that we are very, very transparent as things are. We have got fixed tariffs. Everything is regulated. All the associations have a very beady eye on the tariffs which we use, and it's beyond us how it is that in the regulation I can talk about free access, freedom of access. One wonders why that's in the same breath as funding transparency. So this is an invitation to you. Do come to Germany. We sometimes have the impression that Commission people don't really know what's going on in the ports. Now, I'm not making any allegations. Mr. Fleckenstein didn't come today, but I must say so far I've been surprised that you get someone, Mrs. Vils, talking about the dock workers being in the ports package 3. This is news to us, and this was a bit of came as a bit of a bombshell. And if that were the case, then of course we would go straight, we'd beat a path to the door of our government in Germany, because piloting is a state function in Germany, and that would be something to refer to the government, if were that to be the case. Now, another area we've got major concerns is the next generation, because we think it's going to be ever more difficult to get people to come and work as pilots in future if this gets through. Now, let me just explain why that is our fear. Piloting is, by and large, a secondary. People do not go straight into the world of piloting. People tend to have worked elsewhere before they apply. And being difficult is proved difficult to attract young people into the maritime trades at all. And it's very difficult to see where the incentive is going to be, because it seems that this is it's going to make a secondary profession some years down the road more unattractive or less attractive. And if it's going to be seen as being one which is low scale, low qualification, low wage, then I think that's going to turn people off. And they're not going to make it to the point of applying to be pilots. Now, of course, in certain countries, Romania, other countries, you have got self-employed pilots who can strike. They've got the right to strike. Now, it's perfectly possible that companies see their profit margin squeezed, where you do have a strike on the part of the pilots. And the question is, who's going to step into the breach? Who's going to take on that responsibility? If the providers are no longer doing the job, if the operators are not doing the job, then others have got to be there in order to do the job. But of course, that's not the case with pilots, and the opposite is the case. If the self-employed pilots strike, I think you will have understand the point. The question is, who is going to do the job if someone is not going to? If someone downs tools, as it were, if you do not have employees, those employees are under certain restrictions. They are not at liberty to strike, and I think that there is a justification for the so-called monopoly. And as I said, these are functionaries and employees, and have to work under such restrictions. So the problem is going to be keeping people long-term in the sector, and that's something which the EU is going to have to face. What will happen with employees, where there is a right to strike? What will happen in the event of someone else having to do those jobs? Is there a secondary source to take up the slack, as it were?
Please, the floor is to Robert Želja from Croatian. He's from the Dockers Trade Union. And then after there will be Georgios Papavasiliou. Now up to Robert.
Dobar dan svima.
Good afternoon. I'm Robert Stelja. I come from the Dockers Trade Union of Croatia. Well, what I have to say mirrors what my colleague from Portugal has said. In Croatia, we have seen this in action since 1994, when we first saw the black market in labor, in unregulated labor. We have been fighting that since then. How is it possible to fight it? It's very difficult. A couple of years ago, we came up with an idea, and we're trying to impose the port matricule, where we would issue such certificates to all those who are trained to be dockers, and only they would be able to work in our ports. It's heavy going, but step by step, I think we are achieving some progress, and I hope that we will get some assistance from the government too. And as for the rest, well, I can see now that Greece and Portugal are experiencing the same kind of things that we are seeing, and it's probably going to get worse. Thank you.
Thanks a lot. Georgios Papavasiliou is from Greece, and exactly from the member of the board of Greece Port Employees Federation.
Κύριος Παπαβασιλείου.
Mr. Papavasiliou is my name. I'm in the board, the board of Greek dock workers, and on the management board of port operators. Now, I don't think I'm going to be adding anything new to the discussion if I say that ports are strategically important in the transport picture. This is central to the geostrategic position of countries and their ability to, they loom large in the world of defence as well. However, the point I do want to make very clearly is that who are the ports there to serve? And we have to ask ourselves the question, growth, development, but who is that development designed to serve? And what should be the content of the struggle of the labour movement, of the workforce? The Greek government talking about, with the legislation on access to the market in port services and financial transparency, is simply advancing the process of capitalist restructuring, which is competitiveness driven and is there simply to maintain profits. The capitalist system in Greece is doing exactly what this is all about. The management SEBO in Piraeus with Costco in 2008, before the memorandum, before the Troika, was pushing down this path even then. And this is simply to serve the interests of capital, to maximise profits and to pursue their overall corporate interests. Now, in practice, this is why we are having the response to the question, why are they selling things off when they are making a profit? Now, at a time of a deep capitalist crisis, we're going to see an ever greater process of concentration, and it's going to be at the expense of quality, it's going to be at the expense of the people's wages and conditions. And who is the employer? Is it going to be the port management? We're going to have a workforce which has got no rights in privately owned port companies. And I believe that this is a strategic option by the European Union in the wake of the Maastricht Treaty, which is now bearing its fruit and which is now bearing down on working people in this sector. I believe that the capitalist crisis is speeding up this process of a race to the bottom, and there is now open warfare between the monopolies themselves. The European Union has come back at this, for example, with looking at the ownership situation, companies such as Costco. The internal contradictions are there for all to see, and they're now coming out into the open. And I believe that the workforce have no interest in giving or lending any support to these initiatives from the European Union. And I think that instead of being at the expense of people and piling on the agony, we have got to take on the monopolies and take on the interests which are concerned. The government has shown some demagoguery when it comes to the current grand coalition of, and if you look at the port of Piraeus, the so-called OLP, and look at how the concessions are being awarded, look at the PPPs, the public-private partnerships, and this is really an insult to the workforce, and it's just there in the best interests of their capitalist masters. Now, Syriza voted for Maastricht and voted for a ports policy in 2008 is also not helping the working people either. And this is just serving, again, the interests of capitalists in the ports. In Piraeus, for example, we have seen a steadily worsening situation. The OLP, the Piraeus Port workforce, has been slashed, has been cut. There have been layoffs, and that's the case both in the OLP and in COSCO as well. Collective agreements and trade union representation in COSCO are now a dirty word. In fact, they're not permitted. And with the given the fact that collective agreements are simply being ripped up, and what this has confirmed is that competitiveness is the only benchmark, and people's right to a decent job are completely at odds with this. Now, I believe that governments would not have managed to push this through unless they had been allowed to do that. And this has been, as I say, at the expense and on the backs of the workforce. And what we need is a complete change around so that the workforce is able to stand up to this downward pressure from capitalists. Let's not get it fall into the pitfall of suffering at the expense of monopolies which are fighting between themselves for market share. Let's remember that we have got, if we are mobilized and organized, then we will be able to stand up to this. We must look at people's social requirements and not just the narrow demands of the profit-seeking monopolies. The ports are there for the people who work there, and they must be under some form of social supervision. The class struggle is prepared to take on our opponents, and we will need to mobilize and rally around and pool our resources if we're going to stand a chance.
Not have the time for everybody.
Ευχαριστώ πολύ. Μισό λεπτό.
Okay, if I could just finish, and my final point. The communist forces and the pan-Hellenic labour force, we are fighting to take this battle to the capitalist forces, and we are having to rally all our forces, and we need all the support we can get. Thank you very much. In the 6 minutes. Thank you so much for giving me that time.
Realise that we're doing a good job, so why try and slate us for doing a bad job and calling us inefficient by going in getting an ideological man called Hoydunk to tell us how lazy we are? Now, I tell you, if you're going to be serious in this, my view that the parliamentarians in this place, after rejecting it twice, should look at the Commission and say, what is their motive? What is their motive? Because they say cargo handling's left out. Well, we know this is a foot in the door. If you can get rid of a highly skilled, highly trained pilot to the market, then you can do anything with us. Well, we're not going to stand for it. Because if that's a threat of more liberalisation, we should do exactly what we did in Port Package 1 and Port Package 2 to fight any liberalisation by the Commission. And I hope parliamentarians in this place remember how they voted last time and do it again. Because it really is the creation of precarious work. And that's all you want to do to massage the unemployment levels that are rising in Europe. And the creation of jobs, I'll ask you what jobs they are, Mr. Teoligis, because you told me once, we're privileged, we should be like ground handlers. Is that how you apply to everybody else who works in the port industry?
Thanks a lot. Thanks for a very concise intervention, and of course we'll listen to the different replies we are going to get. Now vamos a bajar a España. Los puestos.
Okay, we're going to talk about with Ernesto Gómez de la Jera. Good afternoon. Firstly, thank you, the European left-wing group of the Parliament, for providing us the opportunity of coming here and explain our positions. What I'd like to say from the Comisiones Obreras is that our position is totally in line. We all think that this draft regulation is absolutely unnecessary. And of course, we understand what the true underlying motivations must be. Now, the Commission may have thought that having failed in the first two port packages, that all they have to do is try to make this regulation to try to compensate for the situation, thinking that, let me repeat, we do not need any third port packages without handlers. In other words, the idea is divide better and rule, and this can't work. Comisiones Obreras does not only present handlers and dockers, but the majority of the Spanish workers in technical and port services who should be affected by this regulation. But don't worry, we are going to fight with everything we can, tooth and nail, to make sure this regulation to never be approved. We're going to do it through our representativity, through the workers affected by it. I am not a docker, but my comrade here on my left is, yes. And he's also from Comisiones Obreras. Now, in principle, we understand and believe the good intentions of the Commission and their declarations of goodwill, but there's a proverb that the road to hell is covered and paved with good intentions. Of course, at this point, the Commission should read the documents that the very EU has been making on the social reality in Europe at this time. What social reality in which all of these drafts that the Commission is making out throughout these years, which are so intelligent, because this regulation would only lead to deepening the division into a very small group of rich getting richer, and the poor working conditions, and then the conditions of work of those supporting the EU, the working conditions would get worse and worse, because what it's all about in the EU is not just free markets, but the liberty and freedom of citizens. At least that's what the actual plan is. And therefore, regulations like this have no place. What we're trying to solve and regulate here, because I'm not going to elucidate because other people have already spoken to this effect, but all I can do is repeat that we're talking about safety here. Safety. For this reason, certain things cannot be done, but there are examples that, indeed, where workers' rights will not be affected. Well, that's good. Where there are transparency, there are certain degrees of transparency. For example, in Spain, there's one port where we already have, there are very few, we've had a regulation on this. There's a case where in a port, we have one port where you've got two mooring companies. This is the port of Barcelona. There's always been a mooring company who had perfectly regulated social conditions for the workers. Now, once the second one of these came in the last 2 years, what happened is that the conditions for workers totally deteriorated because of this. Why? Because the company, the new company, is trying to compete with lower wages, and of course, the previous company, which was complying with the collective conventions, what could they do? Either they had to close down or do the same way. These are the adverse effects of what the Commission is trying to do. Now, as for strikes, of course, I'm trying to believe that the Commission is not trying to call into question the right to strike. Of course, all of us are older now, and that the opinion in the Commission, the Commission draft against the law of the Dockers actually called into question Convention 137 of the ILO, which was ratified by Spain and the Spanish law expected. And this was being undermined. So when you tell us that you don't want here, through this regulation, when you don't want to undermine the right of strike, I'm sorry, I think we have a reason to be skeptical, and we are in Comisiones Obreros. Now, just to conclude, let me remind you that there is something that the representatives of the GUE said in Europe in their first intervention, that Mr. Feroditis did not answer this point, and that is, why is this a regulation and not a directive? No one's answered that question. Now, for us, this is a hugely important point. This is a hugely important point because a regulation is much more damaging in their consequence than a directive. Because if, actually, I don't really know, if you want to legislate in favor of some countries where things are not sufficiently regulated, then a directive would suffice if that's the purpose, because it's possible. I don't know what the situation is in all 28 members countries, and so there may be a country where ports are not regulated. But in the huge majority of countries, the situation of ports is perfectly regulated with safety conditions and conditions of transparency which are perfect. So why do you want to have a regulation and not a directive? Thank you very much, Ernesto. We're going to now give the floor to our director of the group, Angurakis, from the Greek Communist Party.
Mr. Angurakis, thank you. Can I express greetings from our party? Clearly, on the face of it, we're now engaged in a kind of tug of war, indeed a kind of open warfare. And I think we've got to find our way back to the grassroots, and that doesn't often happen in the European Parliament. If you look at the next round of the onslaught, it's clearly an attempt to bring the port services under the heel of capitalist forces. And this is clearly going to bear down on ordinary people at the grassroots level. And the European Union is going at this full speed ahead. And this, I think, is the clear agenda of management. And this is simply being forced through at the behest of capitalists at a time of a deep capitalist-induced crisis. And this is the end of social dialogue across an entire sector. And this is a kind of Trojan horse. The crisis has become an excuse for a new round of squeezes and pressure and restrictions. It was the capitalist system which has produced the current crisis, and it's not really a question of whether it's going to be a local or an imported monopoly. The strategy of the European Union, which is pro-capitalist and competition-driven, is going to mean more capitalist barbarity. That is, not putting it too strongly. And we're now seeing another attempt at engaging in prosecuting another port policy. This is simply seeking to underpin the strength and the position of the monopoly at a time when the capitalist crisis is all around. And they're trying to crank up the capitalist engine once again. The only way for Greece to emerge from this is to move away from the European Union, to leave the Union, and the port services should be brought back into under public control and ownership, and that's what the Greek Communist Party will continue to fight for in its ongoing struggle. Thank you very much.
Jordi Recona, de Catalonia.
Buenas tardes.
Good afternoon. I am Jordi Lagunde. I am a docker in the Barcelona port. I represent the state coordinator of the seafarers, which account for 80% of the Spanish dockers. I'm a member of the IAGC, and when I refer to dockers are working in the port, and they've been doing their everyday work. First of all, I would like to thank the GOEs for taking this initiative today. I think it is a very important one. And why not the Directorate General for Mobility? And because I know it's not easy for the Commission to be here hearing these very blunt truths, but I think it's very important to have these contacts. Let me just put a question and make a couple of brief remarks, because I think we need to hear from the Commission, have our questions answered. As you all know, in Spain, we have a three-phased social dialogue. We have the ports union who've associated with two parties, which represent 80% of the Spanish party. We've got the Spanish Socialist Party. We've also got agreement with the docking companies, Hutchinson, AP Terminal, and we're working with two international companies, and then we have dialogue with the trade unions. Spain is a country where we cannot deceive ourselves. The crisis has been just as complicated as in Greece. We've got pretty much the same employment rate as Greece, and Portugal even more. And of course, Hutchison and Marielle has made certain production efforts to promote safety and workers' health. And in Spain, we had a record of exports in 2013, and we had agreement with the employers, the governments, and the trade union. And we hope that the Commission will accept the report and bring it to the government. When the government pays when you see how much they charge, since the government wants to defend a law, we'll have to see what will happen if the report we're making will follow the proper path, since we are in compliance with the ILO convention. I must say that 10 days ago, the government approved a state port which would allow for greater flexibility with all the trade unions. We had a state agreement between the trade unions and the employers, which was published by the Spanish government. And we don't understand whether the Commission wants to regulate or deregulate, rather than being interested in PPPs, and rather than just concerning competitive with the traffic flow. Instead of flow, they're doing things that will lead to the workers losing their rights. It seems like the Commission has changed, because years ago, the first port packages were really under attack. And we see what's happening in Greece, Spain, and Portugal, and in Belgium, certain things are going on. And if we approve this, I'd like to take advantage that the director of the DG Mobility is here. And since the port workers are going to fight and we are going to win the battle, thank you.
Muchas gracias, Jordi.
Thank you very much, Jordi.
Un'ultima intervenzione.
A last intervention, it's Arifantones from the Thessaloniki port.
Otras pedidas de intervención.
If there are no further interventions, we will give the floor to those who wish to take it. And to those who introduced the discussion, firstly, I think, we will give the floor to the European Commission. So we've got that last contribution from the port of Thessaloniki, Tantafilios.
Está aquí.
Σας ευχαριστώ.
Thank you very much. Afondolidis Tantafilios is my name, and thank you for this opportunity to come and meet with you today. I work in the port of Thessaloniki, and I'm on the staff supervisory group. And in connection with our port, the economic situation of the port of Thessaloniki has stood us in good stead. When it comes, for example, to bulk cargoes. And if you look at what's happened, things have got much worse since the Troika. We are supposed to be supervised by a state government, by state management. And we are seeing an investment situation which is in breach of the competition rules. And let me say that for the past 3 or 4 years, there has been a ban on recruitment in the port at a time when many people have been taking retirement and they are simply not being replaced. And with regard to Article 14 of the relevant legislation, we are having a squeeze on the funding for the port. And there is a strategic responsibility for the financial health of ports so that it's possible to extend and expand the operations. And there are major problems here. We need to see an investment effort being made in the port. And we want to see an increase in traffic and in the yield. My question to Mr. Theogolitis, what's the situation with regard to the operators and the revenue from the charges for the use of infrastructure? We are talking here about private operators, and the whole question is, what are the operations that come into this area? Could we end up with an economic fund which does not have the necessary experience to go about its business? Thank you.
Thanks a lot. Now we can go back to each panelist. I think, as asked by everybody, the first intervention, which maybe he will not give all the replies, but that even reopen the debate and keep the information you need and we need too, will be Dimitrios Theologitis, and then we'll ask to the other panelists if they want to add something, and then given the conclusion to Sabine Weiss, the floor to Sabine Weiss. Please, Mr. Theologitis, if you can in 5 minutes, in order to leave the place to take the floor also to the others. Thank you.
Thank you very much for giving me the opportunity to come back and respond to some of the questions. There have been a lot of positions taken during this debate, and it is obvious that in the time I cannot respond to all. I will, please allow me, as a Commission official, I'm a civil servant, I will try to keep away from philosophical or political position taking, and I will just try to concentrate on some factual information and on some clarifications which have to do with our proposal. First of all, one clarification about the numbers. The Porteous study has been mentioned. The Porteous study is about dock labor. It is a description of the dock labor system in Europe. I think most of you, what they meant was the PricewaterhouseCoopers study, which was mentioned also by others, and which was a satisfaction survey of the users in Europe. The 80% number is not an average. It is a number taken for a certain category of users for a certain particularity. And if you wish, I can come back and explain what that is. The average user satisfaction is only 60%. And if we talk also about some particular services, let us take pilotage, where the satisfaction about the quality of the service is 80%, but where, and please take note, the satisfaction about the pricing of the service is the lowest with 49%. So this is something, yes, this is something that, if we're talking numbers, I would like to put this in perspective. Also, since we're in numbers and since the OECD studies were mentioned, I would just like to take you to a study on the quality of logistics in countries, which includes ports, and where the European countries rank from number 3, one particular country, to number 79 out of 100 countries surveyed in the world. So, the statement about all ports functioning to the top of the ability needs to be taken with a pinch of salt, because there are some international organizations who, according to very precise objective criteria, do the ranking. Also, let us go to a World Bank study which has measured the efficiency of terminals in European ports, and where no European port is amongst the top 20 in the world. There is no European port in the top 20 in the world. So we are very proud of the European port system, but you must please have an open mind that it is not perfect. And of course, as European Union, we want to make it as good as possible. We are also, while we're still in the numbers, about a half page of justification, you are referring to the communication, which according to the Commission standards has a maximum size of 12 pages. So we gave half a page to this. However, there is the impact assessment study, which is 300 pages, available on our website, and where all the issues about the justifications, the economic, the subsidiarity are taken in. And if you're too bored to read 300 pages, I can refer you to the summary of the impact assessment study, which is only, in inverted commas, 30 pages. So there you will find all the justifications, also about the choice of instruments, about the economic justification, the social justification. Still on the subject of numbers, where will the jobs come from? If the 50% growth in the total goods carried by maritime transport does come in, and we foresee that by 2030, it is of course an estimate. It can be 2028, it can be 2033. Please do not take this as gods, because it's just a projection. But if the 50% comes in, which will be facilitated by a good legal system, by legal certainty, and by a fair and level playing field, then you can imagine that with a 50% more volume, certainly the jobs will follow. Of course, this does not mean 50% more jobs, because there is mechanization which is advancing, but certainly there will be more jobs coming. So let us leave now the issue of the numbers aside. Another thing that I would like to say is that I heard many interventions dealing with the question of cargo handling stevedoring. Please allow me not to respond to that. We do not address this issue. We have left it to the social dialogue to address this issue, and we do not wish to address it. However, I would like to use dock work and cargo handling as an example of how legal uncertainty can have an influence on what is happening in the field. The European Court of Justice has had to give rulings which are not managed by a political consensus. They interpret the commas, the conjunctions, the auxiliary verbs of the treaty, and thus the rulings can go into directions which may or may not be acceptable to the social partners, even both social partners. So I want to use this as an example to say that legal certainty, a good legal system which comes through a democratic process as the one we're going through now, is preferable to just an interpretation of a generic principle, transparency, freedom of establishment, or freedom to provide services. So this is why we are doing this proposal. And why are we doing it a regulation? We're doing it a regulation because exactly we do not want national interpretations to provide an uneven playing field. We provide a number of principles which must be interpreted in the same way across Europe. I have been talking around the issues that that you have mentioned, but now I would also like to address some things. Also,
we have to finish.
Yes, yes, I still have 3 minutes. Let me go then into the issue of the technical and nautical services, which I have to say I do not personally like bundling them together because they are different in nature. Pilotage is different than mooring, is different than towage. Each one has very specific characteristics. I would like to ask you to look around the European port scene, which we have to do as Commission. And I would like to say that in all 3 of these services coexist around Europe many systems. There are systems which are completely private, take towage. Some countries do not intervene at all. There are systems which are semi-private. In some countries, a concession is given for a particular service. And in some countries, it is being done as an internal operator. This is exactly what we are describing in our proposal. And we give the legal certainty, and I would very much like to address the pilots in this case. We are giving the legal certainty to the pilots that they can remain a public service. So this is extremely important, because otherwise, or mooring, that it can remain a public service. Because otherwise, you would be at the mercy of the first large consortium, and you have mentioned the P3 and the G6, you would be at the mercy of the first one who comes and makes an alternative proposal. And then, is anyone around the room who can tell me how the European Court of Justice will rule? I personally cannot tell you in advance. So this is why you need the cover of the regulation in order to have the legal certainty which establishes the fact that member states may decide that a service, one of those nautical services, is a public service. This is recognized in the regulation, and we have the whole system which is there. We recognize, in fact, the public monopolies. When it's private monopolies and public monopolies, the price to pay, of course, is transparency in the pricing. Yes. One more aspect. You can come to tell us all you want about safety. Please tell us more. You are walking through an open door. There is no wish from our side, I mentioned that, to reduce at all any safety level. So talk about it. You are, as I say, this makes no difference. We have every intention in making sure that there is no safety principle which is attacked by our proposal. This proposal, you mention it as being the same as Ports Package 1 and 2. The only thing that they have in common is the word port in the title. Nothing else is common. It is completely different. The justification is different. The content is different. And the articles, the wording themselves are different. So it is not in the wake of these proposals. Please deal with it on its own merit and not burdened with the past, which has been done many times around this. Thank you very much, Madam President.
Okay. May I go through the other panelists before giving sufficient time to Sabine Weiss to conclusion and ask, starting from Gogos, Colombite, Tetard, and then going on my left side, there are a few remarks for 1 or 2 minutes in order to leave, not from your side. From your side, Mrs. Livia Spera, you want to spend one more word and then...
Just very briefly to say that controversial issues remain for us. We are fully engaged in a dialogue with the MEPs that are involved. With some is more fruitful, with others is less fruitful. But of course, we will continue our job in the next months, and of course, we're always available to an open dialogue on this.
Thank you, Mr. Frisch. Any final comment?
Ja, ich möchte auf.
Yes, if I could just address a few points. Firstly, you criticised me in passing, and I think you tried to justify one point that I see no justification for, really from the Green Paper onwards, through the various communications that the Commission has given us, right from 1996 to 2013. It really has not changed its justification behind putting forward these proposals. And I think that that's something that you didn't address properly. These are problems that have simply extended from one area to another, and you've just found different analyses to put forward to justify it. I have the text here from which I've taken out 2 or 3 sentences which relate to subsidiarity principle, and that's really not a great deal. Now, on the question of how workers are affected, well, perhaps just to address the philosophy of it, the critical question here that is the way in which the Commission is now talking about the European Court of Justice, and the way in which that commercial concerns are going above and beyond social concerns. That's really not in line with the treaties, and it's only something that can be brought in through primary law, through the treaties. Now, if the commercial concerns are coming above social lights, I think then Article 8, paragraph 6 is really being applied, where in fact Article 8, paragraph 1 should take primacy. It relates to collective bargaining on wages, and that's something that's been applied in the Federal Republic of Germany. The workers have fought for collective bargaining, and then all of a sudden the traditional holidays and days off that have been enjoyed in Hamburg for a long time are now being revoked, saying that the services have to be provided in an uninterrupted way. And that's really just going against the terms that have been decided upon by collective bargaining. Several speakers at the same time. Mr. Fleckenstein has his opinion on that in any case, but please, it does state this in the proposals. Now, if you don't want it, then don't put it in the text. The right to collective bargaining agreements is being undermined, as is the strike right, and this is dangerous. The Confederation of Unions, and Verdi as well, has said this very loudly. They said we want social progression clauses, saying that social rights are given the same importance in this kind of agreement, and that's something that needs to be brought out more. I think that's really, really important. Yes, okay, several comments at the same time. Well, just one further comment, if I may, in terms of the impact assessment. I think really what's being put forward is really just an intellectual justification for something which has no real justification. It's simply trying to manipulate the statistics to try to justify a situation which is not justifiable. So please, this PricewaterhouseCoopers study, please that's not really a suitable basis, and don't quote that any further.
Sorry, but we have now to go to the conclusion. Give again the floor to Sabine Wills, who will update you on the next steps by our side, but of course all dialogue with the Commission and with our group as well as with the other political group are available. You can write by mail to everybody, as you know, to the email address of the Parliament, to the email address of the Commission, so other concerns are still ongoing, and the debate as a legislative process is still ongoing, both in the Parliament and in the Council. Don't forget also your government representative who are discussing as well as us this proposal in the Council. Please, Sabine.
Ja, wir sind ein bisschen in
Yes, we do have a bit of a time constraint because the interpreters also have the right to their free time once they finish this evening. So, if I may, just talking once more about pilotage, we agree with Mr. Fleckenstein on this, namely that pilotage does not belong in this regulation. However, the Conservatives are still negotiating this, and Mr. De Backer from the Liberals has started this discussion now. And of course, we have to consider the fact that amendments will be submitted from this particular group to the plenary, and that will then be subject to the vote in the Parliament. As such, we can't really then guarantee that that won't go through. So there is a threat that pilotage will be included in the regulation. That may in turn undermine safety in that field, as the Italian representative has mentioned. Regarding the dockers, the port workers, well, we can see what the danger through Piraeus and Costco. We've seen the working conditions that have been achieved over 40 years undermined, and I believe that what's in this text is a genuine threat. Social rights are being undermined. The person responsible for ports in that country has said that if you're on your mobile phone on the port, then people suspect that you might be getting in contact with your trade union activist, and that's considered to be a desperately dangerous measure. So this whole idea of having a Europe-wide contract awarding or concession awarding through calls for tender, that is going to undermine conditions, and the Commission really is stepping up the possibility of precarious work. That's something that we have to fight against. It's not just about the number of jobs, that's what they're always banging on about, but it's also about the quality of jobs. We're seeing more dangerous, more precarious work in ports at the cost of getting a few more jobs. And now, the members of Parliament have already shown, they've demonstrated that they don't want this proposal, they don't want these changes, but we do believe that these activities are absolutely necessary for Europe. So we have to be creative. And when the members come to putting this to the vote again, then hopefully we'll be able to put some pressure to bear. We'll be able to call upon members of Parliament from other groups to see eye to eye with us, and we'll be able to do something together to push this back. So thank you very much, everybody, for the wonderful discussion. This is a topic which is not of interest to everybody, of course, but it is important to see that a lot of people who are interested have that strength to struggle, and we'll all be united together. Thank you.
Thanks a lot to everybody. Thanks again to the interpreters. We are yet in time, thanks to your experience of workers, of our experience to keep in time for the other work. Please address your concern to the mail you have got by me, to Sabine Wilson, as well as to the other political groups, of course. Then people who are located in the Atlas Hotel and did not get the reimbursement application form, please address here, I'll give them.